Distinguished guests, ladies and gentlemen, good morning. Let me start by thanking the Asian Australian Lawyers Association for organizing this summit on cultural diversity and legal profession, and also for giving me the opportunity to speak about topics that are very close to my heart. As someone who has been intimately involved with the judicial system in India at all levels, as a lawyer for 17 years, a judge for more than 20 years, and the Chief Justice of India for 1 year and 4 months. I believe I can add some value to the discussion taking place at this summit, particularly from an Indian context. While the summit relates to cultural diversity, I would take the liberty to talk about diversity in all its varied facets. In fact, I would like to reframe the theme of the summit from many cultures, one voice to many identities, one voice. India is like Australia, is a vast country with great diversity among its people. The rich linguistic, religious, ethnic, and social diversity within India cannot be understated. Perhaps there are not many countries like India in the world which have as many linguistic states as India has. The framers of the Indian Constitution, therefore, had a difficult task ahead of them in the late 1940s when they are required to frame a document that would provide necessary space and security for all these identities. They had to keep in mind the diverse identities and also had to contend with a nation where a vast majority of the population suffered from poverty and illiteracy. The success of the Indian Constitution is a testament to the foresight, efforts, and intellectual capacity of the Indian Constitution framers. However, it also a testament to the representative quality of the Constituent Assembly, be it in the terms of region, religion, gender, or community. I truly believe that the representative character of the Constituent Assembly resulted in various debates from multiple viewpoints, which enriched the Constitution and made it into a resolute document. My country was therefore born out of diversity. Its structures and framework are steeped in diversity. This is the reason why we have a democracy and a representative parliament. These structures, without doubt, are best suited for a pluralistic society like ours. Rich diversity cannot be sustained through dictatorial or authoritarian governance. It is democracy that does so. However, despite the focus on ensuring representation and diversity in the political sphere, very few democracies, including India, have focused attention on representation in the judicial system. It is an issue that is being faced across the world, from the older democracies like the United States of America to younger democracies like India. And due to the differences in the systems relating to appointment of judges in different countries, perhaps there is no easy answer to this. It is without doubt that the absence of an institutional mechanism to ensure diversity on the bench is a problem. Diversity on the bench leads to a diversity of opinions, one that is built upon their different experience in the world. They may have a more nuanced understanding of the differing impacts that a particular legislation or judgment may have on different communities or sections of the society. But beyond that, representation on the bench has the important feature of making people feel like insiders within the system and not outsiders whose fate is being decided by someone unconnected. It has an important signaling effect. It is for these reasons that whenever I had the chance, I attempted to ensure the appointment of judges from diverse backgrounds in India. In our country, the appointment of judges to the constitutional courts, which are the high courts and the Supreme Court, happens through what is known as the collegium system. In this system, it is popularly believed that the five senior most judges of the Supreme Court have full power to decide on who must be appointed to the judiciary. This is a unique system evolved in the Indian context. The Supreme Court of India passed a series of judgments and orders declaring the collegium system to be necessary to ensure independence of the judiciary and to exclude the influence of the executive. However, the fact is that the judiciary is merely one of the many players who involved in the process. Many authorities are involved, including the state or central government, as the case may be, in appointing judges. There have been various concerns raised in different quarters, including by the government, lawyers groups, and civil society, relating to the functioning of the collegium system. These cannot be ignored or brushed aside and definitely merit consideration. However, I am not here to speculate on whether the system in India is good or not, or whether any other system would be better. There are probably a whole host of issues that affect the judicial appointment process in other countries. But it is true that the judges in India do have somewhat more significant role to play in the appointment of judges. I have had some involvement and experience in the judicial appointment process during my tenure as Chief Justice of two high courts and a senior judge of the Supreme Court, and subsequently as the Chief Justice of India. In all my time in the various collegia, and particularly during my time as the Chief Justice of India, I tried to ensure diverse representation on the bench through the recommendations we sent. Almost all the recommendations made by us were cleared by the Government of India. I can proudly state that our recommendations resulted in the appointment of the greatest number of women judges on the bench of the Supreme Court of India at any one point of time. India is also slated to get her first women Chief Justice of India. One noteworthy feature of the district judiciary in India is the greater gender diversity, which is a result of affirmative action by way of providing a fixed percent of positions to women. Of course, improving gender representation is only one facet of improving diversity on the bench. Ensuring the representation of persons belonging to minorities and those from different regions or cultures is also essential. We try to take all of this into consideration while we are recommending judicial appointments. However, I would also like to point out that diversity on the bench should not be viewed in an isolated manner. Diversity within the judiciary stems from the diversity of the bar, which itself flows from the entry of students with diverse backgrounds into legal educational institutions. They form the feeder system of the judiciary. We must therefore start by reducing barriers to education and within the legal profession for persons from different backgrounds, social, cultural, and economic. This ultimately will fulfill the end goal to have a judiciary that is truly diverse, mirroring our society and nation. Finally, I would like to state that I think conferences and summits like today's are essential to further this goal. The lineup of speakers of the summit and the various sessions organized provide a welcome opportunity for cross jurisdictional learning that might lead to new ideas. I wish the organizers of the summit, the Asian Australian Lawyers Association, and all the participants a grand success. Thanking you.